Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody. Thanks for joining us. Today, our topic is pitfalls for buying properties at foreclosure sales. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like, subscribe to our Facebook and our YouTube channel. We'd really appreciate that. With that, Sean, what do you have for our legal update?
Well, our legal update kind of goes hand in hand with the topic today, which is foreclosure. And so today we're going to talk about anti-deficiency statutes. And in Arizona, we're one of a number of states nationwide that have anti-deficiency statutes, but they don't exist in every state. They tend to exist more on the West Coast and in West Coast states. So Arizona, California, that type of thing. But basically what anti-deficiency statutes are statutes that protect a borrower on residential property from a lender pursuing the borrower's other assets to recover the loan balance. So if a lender provides a loan to property that falls within what we call a protected class, so it's property that's 2.5 acres or less, that's limited to or utilized as a single one-family or two-family dwelling, so a duplex will qualify. But if a loan is made for that, and secured against that property, then there's certain protections that kick in. And in Arizona, there's two levels of protection. The first level of protection is if the loan is what we call a purchase money loan. So that's one level. And then the second level of protection is if the loan is a non-purchase money loan. So if a loan's a purchase money loan, that means that the loan was used and the funds from the loan were used to purchase the property that falls within that protected class, or to construct the dwelling on the property that falls within that protected class. So if you own own land, and then you go and you obtain a construction loan for purposes of building the residence on that land, that construction loan would fall within that protected class and would be considered a purchase money loan. A non-purchase money loan is a loan that is secured by residential real estate or property within the protected class, but whose loan funds were used for some other purpose besides purchasing the property. So a typical non-purchase money loan would be your HELOC, where you've basically used those funds to pay off credit cards, to maybe buy a car, or maybe even buy another piece of property that's unrelated to the property that the loan was for. And in that case, it's a non-purchase money loan. So the difference in protection lies with the remedies that the lender pursues to enforce its loan documents. So a purchase money loan provides the ultimate protection. So under no circumstance can a lender pursue a borrower's other assets to recover the loan balance if the loan was a purchase money loan. So if the loan was, say, $400,000 and the property is only worth $300,000, and the lender goes and forecloses on the property, leaves $100,000 debt or deficiency. So there's $100,000 that the lender did not receive. What's the result? And the result is the lender doesn't receive that. The lender does not receive that $100,000. They're out $100,000, and there's nothing the lender can do about it. That's the purchase money scenario. In the non-purchase money scenario, the lender basically has three options to enforce its loan. The first is to do nothing and sue to recover the loan balance. So if it's a $100,000 HELOC and the property's upside down and the lender realizes, hey, I'm not going to receive anything out of this property, so I'm just going to take steps here to enforce my loan, and I'm going to go and file a lawsuit. I'm not interested in the property. I'm going to file a lawsuit. that lender is allowed to go and file that lawsuit. A lender on a purchase money loan cannot do that. Their only recovery is the property, but a non-purchase money lender can go and file the lawsuit, serve the lawsuit, and try to obtain a judgment against the borrower for the amount that's owed on the loan. The second option available is for the non-purchase money lender to proceed to a judicial foreclosure. And we're going to talk about that a little later on, the difference between a judicial foreclosure and a non-judicial foreclosure. But they can proceed to a judicial foreclosure, and which is a foreclosure through the court system, and then obtain their judgment, go to sell the property. And then let's say it's $100,000 HELOC. And as a result of that judicial foreclosure, they're able to recover $20,000, leaving an $80,000 deficiency. They can then pursue the borrower for that $80,000. They can have a judgment against the borrower for that $80,000 and try to go after the borrower's other assets, such as, their bank account and their wages and other non-exempt assets. They can try to recover that there. The third option is to go forward with a non-judicial foreclosure, also referred to as a trustee sale here in Arizona. But that's a foreclosure completely outside of the court system, handled by a private trustee. And they can proceed to that, and that's a remedy available to a non-purchase money lender. The significance, though, of that is our legislature has stated that, hey, look, if you're going to choose that route and you're dealing with property within this protected class, basically residential property, and you foreclose on that residential property via a non-judicial foreclosure, so outside of the court system, and that gavel drops and you sell that property at that non-judicial foreclosure or that trustee sale, you waive any right to recover the deficiency. So if that lender is able to recover $20,000 through a trustee sale, leaving an $80,000 deficiency, they can't recover the $80,000 because that gavel dropped on a non-judicial foreclosure outside of the supervision of the court, and they're out. They don't have the opportunity to recover that $80,000 or that deficiency. So while you have less protection on a non-purchase money loan, there is some level of protection, and that level of protection is dependent upon the remedy that the lender chooses to pursue. If they choose to pursue the trustee sale or the non-judicial foreclosure, they have no right to the deficiency. Their only remedy is the property. But if they choose the other remedies, such as a judicial foreclosure or just a lawsuit on the debt, they can pursue the deficiency or the amount owed against the borrower and the borrower's other assets.
Now, Sean, I'm old enough to remember that back before 2008, nobody ever heard of the Anti-Deficiency Statute. Not even lawyers heard of the Anti-Deficiency Statute. And then over the course of 3 years, everybody at their kitchen table knew what the Anti-Deficiency Statute was. Now, for the last 10 years, nobody's been talking about it, and we're talking about it again. So why don't you explain for the audience kind of the market dynamics of why we see that in different stages and when deficiencies seem to be an issue and when they don't?
Yeah, before 2008, the anti-deficiencies or anti-deficiency statutes were never an issue because there was never deficiencies, because you had, rapid appreciation of property values. So a lender was either fully paid because from a borrower's perspective, if I have a property that I owe $300,000 on, and that property is now worth $600,000, but I can't afford to pay my mortgage, well, I would be dumb to just hold on to that property and let the lender foreclose, because you're going to recover less at a foreclosure sale than just a traditional arm's length sale. So in that case, I'm going to list that property for sale. I'm going to pay the lender in full. Or let's say you do have a homeowner who's going to just stick it out and say, I'm going to live here as long as I can. I'm going to let the lender foreclose. And the lender does foreclose. Well, they're going to recover their loan balance because there's so much appreciation and so much value in the property. But what did we see in 2008? We saw massive depreciation. We saw properties going down in value on basically a daily basis, to the point where, almost every property, at least here in Maricopa County, and some of the surrounding counties, I mean, they were underwater. 90% of the homes were underwater.
And it all felt like it was overnight.
Yeah, and it all felt like it was overnight. And so at that point, you know, borrowers had to decide, homeowners had to decide, well, what am I going to do? I'm struggling financially because we also had a recession, right? And we had job loss and a decrease in wages and things like that, that all of which was compounding the situation. And so you have people who are saying, okay, well, do I take from my 401k and pay my mortgage, or do I figure out a way out? And that's when, these anti-deficiency statutes came into play, because people were wanting to know, well, what's the worst case scenario? What does that look like? Now, what we did talk about when we were talking about the anti-deficiency statutes and liability on these loans, we didn't talk about credit. Obviously, a foreclosure is going to have a negative impact on credit. And so that is something negative that comes from the foreclosure. But on the flip side, people wanted to know, okay, well, am I going to end up in court tomorrow? Is the bank going to come the next day and say, hey, you didn't pay your mortgage, be out of the house? What does all of that look like? What are the timeframes that we're dealing with here? What's my exposure? Am I going to end up basically, bankrupt and penniless? And at least here in Arizona, there was decent news for a lot of homeowners. Never a great situation, but it did provide some comfort to know, like, that Arizona has these statutes in place to provide some protections to a borrower for residential property. One final note that I want to make that I didn't mention earlier, and it's an important note because we represent a lot of investors and investors in single family residences, some investors in duplexes. The anti-deficiency statutes apply regardless of whether the property is owner occupied. So nowhere in my prior discussion did I ever state that the property had to be owner occupied, because it doesn't. It just has to be within that protected class, which is 2.5 acres or less, limited to and utilized as a single one family or two family dwelling. There's nothing in the statute that says limited to and utilized by the owner as their single one family or two family dwelling. That term owner is not in there. It doesn't require that. It only requires that it be used as a residence by the owner or someone else. It could be a tenant. It could be a guest. It could be, someone else utilizing it in that capacity. So there is no owner occupant requirement for the anti-deficiency statutes to apply, which is important because there were a lot of investors who went out and, in 2005, 6, 7, over leveraged themselves and bought a lot of, quote unquote, investment properties using financing. And then when the market shifted, rental rates went down. All of a sudden now the rents weren't sufficient to make the mortgage. And so these investors had to decide, well, what do I do? Is there an exit strategy? And fortunately for them, the anti-deficiency statutes provided more protection than I think a lot of people thought.
Yeah. And of course, we're talking about Arizona specifically here in the anti-deficiency statutes as they apply in Arizona. But what a lot of people that weren't around for the last recession probably don't appreciate is when we say deficiency, we're not talking about a few $1,000s. When you've got borrowers that bought at the top of a bubble, essentially, unknowingly, and it burst, you're talking about borrowers who lost their house and are also facing a deficiency of potentially hundreds of thousands of dollars. So it can be a huge benefit and something to know about. There are similar statutes in other states. If you're an investor or a borrower in those states, you should look at that as it applies to those. But
Well, and I do want to comment on that for a minute, just on the exit strategies and the
sure,
impact of having anti-deficiency statutes versus not having anti-deficiency statutes. So one of the things that, we saw starting in 2008 for 4 or 5, 6 years was short sales. Well, in Arizona, a borrower slash owner of property, of residential property, had a lot more leverage to negotiate a short sale and complete a short sale than, say, a borrower in a state where anti-deficiency statutes don't exist. Because in those states, now you're working to negotiate with the lender a release of liability. So, the lender has a lot more leverage. Here in Arizona, the borrower could say, okay, well, if you're not willing to do a short sale and let me sell this as arm's length and provide you a greater recovery on your loan, then I can just walk away. Yeah, it might have a greater damage to my credit, but you're not going to be able to come after me and you're going to lose more. Versus in a state like back east, for example, some of the states back east, it wasn't that simple. Then it was more of, hey, I want a release of liability in conjunction with this short sale. And you have lenders saying, okay, well, how about coming to the table with some money? Because we have the ability to pursue you for a deficiency. So the anti-deficiencies, not only do they provide a certain level of protection and comfort for borrowers in the states where they exist, but they also provide a greater leverage for a better exit strategy in those states as well. And then my last point is, to the extent short sales ever come back, it's very important to make sure that if you are in an anti-deficiency state and you are going to complete a short sale, that you receive from the lender a written release of liability, because a short sale is basically doing an in run a little bit around our foreclosure statutes, right? And so you want to make sure that you receive it in writing, that you're going to receive the same level of protection via a short sale that you would under an anti-deficiency statute.
Right, because the application of the protections of the anti-deficiency statute in certain cases depend on a foreclosure event actually happening, right?
Correct, yeah.
All right, with that, it's a good transition to talk about our main topic today, which is foreclosures. As Sean mentioned, our show is primarily about real estate investors, real estate investments. And one of the big areas for real estate investors is purchasing property in foreclosure, at foreclosure auctions or foreclosure sales. So we wanted to devote an entire episode to talking about the pitfalls that real estate investors should consider when they approach an opportunity at a foreclosure sale. So why don't we start with types of foreclosure sales? So not only are there different types of foreclosures nationwide, we're a country of 50 states, it's done a little bit differently in every state, but there's different types of foreclosures even within a state, and Arizona specifically. So Sean, what kind of foreclosures do we see here specifically in Arizona?
Yeah, so in Arizona, we are what you refer to as a deed of trust state. And the deed of trust states are going to have generally two types of foreclosures. So when a lender makes a loan in Arizona, they can secure that loan by two types of liens. The first lien is what we refer to as a mortgage. Now, just in talking, and I even said this in my prior intro, I said, well, if you're not going to make your mortgage payment. Well, in Arizona, we really don't do mortgages anymore, but that is a type of lending instrument and lien instrument that can be used to secure a promissory note, and they're perfectly legal and allowed in Arizona. But lenders don't really use them. They're used in other states. There's states throughout the nation that are mortgage-only states. There are no deeds of trust in those states, and so the lender only uses a mortgage. The significance of a mortgage here in Arizona is that it has to be foreclosed through the court system, and there's no way to privately foreclose the mortgage outside of the court system, which is why lenders don't use mortgages. They use deeds of trust. A deed of trust is basically a lien instrument that's used to secure a loan against real estate, and it appoints a trustee who holds what we term bare naked legal title, which basically means the property is placed in trust with this trustee who has very limited powers or say over the property. Their only role is to foreclose on the property if the lender's not paid. But they are a private company or a private individual. So in Arizona, you have real estate brokers, attorneys, and title companies who can serve as trustees under deeds of trust. And they're the ones that are entitled to foreclose and start a foreclosure sale and complete a foreclosure sale on the deed of trust outside of the court system if the lender doesn't pay. But a deed of trust can also be foreclosed judicially. It can be foreclosed in the same way as a mortgage can be foreclosed through the court system. So in Arizona, when we talk about the different types of foreclosure, we're talking a trustee sale or a sheriff's sale. A trustee sale is the sale that's done outside of the court by a privately appointed trustee under a deed of trust. And it's the trustee's fees are capped at the greater of $500 or 0.5% of the then outstanding principal balance of the loan. And it can be completed in a 90-day period. There's no judicial oversight. In fact, the sale is going to be generally deemed valid unless the borrower goes into court and actually brings it to the court's attention that there's a problem with the sale or a problem with the lending instruments or whatever the case may be, and obtains a temporary restraining order no later than 5 p.m. the night before the sale, stopping the sale. And TROs, that's a pretty high burden. And so it's really completely outside of the court system, and it's pretty hard to stop a trustee sale. And it's a, fairly cost-effective and efficient process to go and foreclose. A sheriff's sale, on the other hand, requires the filing of a lawsuit, the service of that lawsuit, and then the borrower has the opportunity to answer the lawsuit. And then at some point, a judgment must be entered in favor of the lender. And then from there, the lender obtains a writ from the court instructing the sheriff of the county where the property is located to sell the property at a sheriff's sale. So it's a process here. And there's no statute that caps the amount of attorney's fees that can be charged to a lender and then passed on to a borrower for a non-judicial or a judicial foreclosure, a sheriff's sale. So all of those fees are going to add up. And so it's a costly and time-consuming process to do a sheriff's sale because it requires basically a judicial foreclosure. It requires a foreclosure through the court system. And then finally, on a sheriff's sale, you do all of that. You get your writ. It tells the sheriff to sell it. The sheriff notices the sale, does everything that they're required to do. They then auction the property off at a sale. Well, guess what? Now there's redemption rights. And all of a sudden, the borrower has 6 months to go to the purchaser and pay certain amounts, which we'll discuss a little later on, but they have the right to pay certain amounts to the purchaser at the sale and redeem the property, take the property back. So once again, it is a process versus a trustee sale. The minute that gavel drops, with some exceptions, which we'll talk about, but the minute that gavel drops and the minute that the trustee's deed is executed by the trustee in favor of the purchaser, title conveys. There are no redemption rights. There's no 6-month waiting period like you have generally in a sheriff's sale before title is actually transferred.
So let's talk about the potential pitfalls that borrowers are facing purchasers are facing when they've decided they're going to buy a property. So they've decided, let's say, in Arizona, the most common one is the trustee sale. They're going to purchase property at a trustee sale. A trustee sale can happen on the courtroom steps, or it could happen at the trustee's conference room at their office, wherever essentially they've designated where that's going to be. So you've shown up and you're ready to just make a killing and get the best deal ever at a trustee sale. But there's pitfalls. There's things we want you to be aware of. So let's talk about trustee sales first. What I would call kind of a first major pitfall, but not understanding lien priority. Why don't you explain that?
Yeah, and not understanding lien priority is actually a pitfall under both a sheriff
Sure.
sale and a trustee sale. But in the trustee sale context, you have to understand what lien are you buying. I've had clients who have gone to trustee sales. They've purchased or they were the winning bidder at the trustee sale. They provided their check to the trustee of the initial $10,000, and then they've come in with the remaining amount, and they now have a trustee's deed, and they're thinking, hey, we have an amazing deal here, right? $80,000. This is awesome.
They're already counting their money.
They're counting their money. And then they receive in the mail a notice of trustee sale. And they say, well, wait a minute, a notice of trustee sale. Why am I receiving a notice of trustee sale? And then they come to me and we sit down and we do a little bit of research on the property. And I inform them of the idea of lien priority and say, well, wait a minute here. Did you know you were buying a second position lien that was being foreclosed? Did you realize that that's what you were bidding on? And that there's this first position lien out there for X amount of dollars, say 300,000, that's out there. And now they're going to foreclose. Now, hopefully in an appreciating market, not the end of the world. There's certain things that can be done, such as reinstating the loan. You have a right as a subsequent owner of the property, as a successor in interest to the property, or even as a second position lien holder. You have the right to reinstate that loan balance, and you have a right to make monthly payments and to keep that loan current. You have a right to pay it off. So if the property is worth 50,000, you put in not 50, 500,000. You've put in 50. The other lender is owed 300, and you sell it. I mean, you're going to do okay, and you were right in counting your money. It's just not as much as you thought you were going to receive, right? But if you don't understand lien priority and don't understand, what you're actually purchasing, that's a problem. Another instance of this is HOA liens and HOA assessments. And so you think, okay, well, I know that I'm buying a second position loan, but the only thing ahead of me is the first position lender at 300,000 and the property's worth 500. So if I can get it for, 50 grand, I'm golden. Well, HOAs have priority, and their outstanding assessments have priority to second position deeds of trust. They're junior to first position deeds of trust, but they're senior to second position deeds of trust. And so all of a sudden now you're served with a lawsuit from the HOA, and they're in the process of foreclosing their HOA lien. And you're like, wait a minute, the HOA says, the outstanding assessments plus attorney's fees and all of this, stuff is 30 grand. Do I have to pay that, or did my purchase at the sale wipe that out? Well, if you bought a second position lien, no, you're on the hook for that 30. So once again, you're still going to, if my numbers, play out where it's worth 500, first position is 300, you bought it for 50 and the HOA is owed 30, you're still going to come out ahead, but just not as much. But if those margins are smaller, you may not come out ahead, and you may have spent $50,000 to buy a property that you might receive zero on. So you just have to understand lien priority. And here's the thing. Right now in this market, at least right now, chances are if you bought a second position loan, there's still equity. But chances are you're not going to be able to buy a second position loan because there's not much foreclosure activity, right? Where we're going to see the foreclosure activity is when there is depreciation and failure to make loan payments and all of a sudden the property is not worth as much. That's when you're going to see it. So then now it's really important, because that's when you're going to have opportunities to buy properties at foreclosure sales, but it's going to be important to understand lien priority and know, what else is out there that's going to take priority that I'm going to have to pay before I see a dime from this property.
Okay, so what can an investor do? They've decided that they found the investment of their dreams. They're going to go to the trustee sale. They followed us. They've realized, well, I got to watch out for lien priority. What can they do ahead of time before that to vet what it is I'm buying and whether it's behind or in front of other liens?
Yeah, the best way to approach that is to run a title search. Either use a title company that you work with or have a relationship with, who you can pay a fee to do what's called a condition of title report, which it's nothing that you can officially rely upon, but it's a search by a title company who's trained to do these searches, and they're going to do a more thorough job than, say, what you can do. And that'll give you a feel for what's out there. So that's one. The second, and it's still not something you can rely upon, but the second thing you can do is contact the trustee. And trustees, before they start the sales process, they run what's called a trustee sale guarantee, which is basically title insurance for a trustee, because the trustee needs to know, who do I have to send notice to have a good sale, to have a proper sale and an enforceable sale. And so they're going to run their own title report and obtain their own title insurance, basically saying, look, trustee, if you go and send notices to this person, this person, this person, you're going to fulfill your requirements under the statute and you'll have a good sale. So they have this trustee sale guarantee. A lot of times the trustees will release that if they're asked by potential, purchasers at the sale. Other times there's a fee associated with that, and they'll release it for a fee. And that trustee sale guarantee will basically is a title report, and it shows exactly what liens are out there, what position lien is being foreclosed, and gives you information. But it not only tells you what liens are out there, but what clouds there may be on title, what easements may exist or not exist. For example, now this is outside generally of the residential real estate, at least subdivided residential real estate. You want to know, hey, is there legal access, legal ingress, egress to this property? Because without legal access, the property doesn't have much value and you can't really do much with it. And most municipalities, before they issue building permits, are going to want to have evidence of the fact that you have legal ingress and egress to the property. So that's one thing. The other is, are there easements out there that would impact my potential use of the property? Common example is old easements from, say, gas companies or electric companies who, went out and obtained easements in order to, run lines and do different things, who never used those easements, but they thought, well, we probably need to run an easement through here. Well, that easement could be running right below where you're planning to build, but the utility company doesn't really care about that easement, but it's going to impact your ability to use that property. So you're going to want to know, hey, is there an easement out there? If I'm going to bid and I'm going to buy this thing at a trustee sale and I want to use it in this manner, I want to buy vacant land at a trustee sale and I want to build on it and construct something on it, whether it's commercial or residential, you want to know, hey, is there an easement out there that's going to impact your, construction? A lot of times those can be abandoned, but it's a process to get the utility company to abandon that easement if it hasn't been used. And then finally, are there clouds? Has somebody, claimed an interest to this property? Were all the deeds leading up to the loan, were those done properly? Now, most of the time, a lender who's providing any substantial loan is going to do their own title work. You can't rely upon it, but you can feel a little bit more comfortable that, it's a sophisticated lender and presumably they've made sure that the title is clear before they made the loan. But do lenders make mistakes? Sure they do. And so you want to make sure, hey, is there some problem with the chain of title leading up to this loan that the lender didn't pick up on that I'm going to have to deal with? That's something also to think about and look into.
Now, we've both acted as trustees on occasion in trustee sales, so we know this process. I have been contacted by interested parties looking to buy the property, and I'll get a call, and they're like, "Oh, we see this is going for a trustee sale. You're the trustee. Well, I sure'd like to get onto that property and see it." And my thought is, well, of course you would. We'd all like to get and go see a property that we want to go buy, but unfortunately, in those cases, I don't represent the owner. I don't even know the owner. And in a default situation, they may not be there. They may not be interested in talking to people. They might not even be in a good mood. Maybe their finances, they're just at a bad time because they're maybe losing their property. So for an investor who's looking to buy, and we're not in the normal closing scenario where they get to see the property, where they get to do an inspection of the property, walk the property line. You don't get to do any of that typically in a trustee sale because it would be trespass. It would be against the law to do so unless you get permission to do it. How can an investor ensure or do some due diligence to make sure there aren't problems with the property, encroachments that they're not aware of? Because that seems to be another big pitfall that investors face.
Yeah, encroachments are an issue. Confirming that walls have been constructed properly, or if they haven't, that there's licenses and easements in place either via the CC&Rs or some other document, or even you have a tree or other structure on your property that's encroaching on the neighbor's property outside of, say, a wall, or vice versa. Your neighbor has built something that's encroaching on the property you're looking to buy. So there's a couple ways to figure that out. Number one, you can't trespass, right?
Right.
So there's no stepping foot on the property for that purpose because that is a trespass. But you could go and drive on the public access road nearest the property and take a visual from there. You can, if it's in a subdivision and there's a sidewalk, you can go onto the sidewalk and look there. You can go on the other side of the property and, look from the street or sidewalk behind the property see what's, there in the backyard and that type of thing. And then another good source is aerial photos, at least here in Maricopa County and, some other counties, the GIS type maps and photos, where you can go to here in Maricopa County, you can go to the assessor's website, you can find the property, and then you can find aerial photos going back about 10 years. What's interesting is, it's kind of fun to play with those because you can really see how the property's changed and developed over the last 10 years.
Sure.
And you can see how people have used it. For example, my house, if I go back, to the prior owners, I can see how they use the backyard, where they put the umbrellas and different things, patio furniture and all of that. And you can see how they utilize the property before me. And so that's kind of interesting to be able to do. But these aerials, I mean, they provide a lot of detail, and you can see a lot about this property via those aerials. And you can also see, and it's not exact.
Yeah, you can't rely on it like you can a survey.
Right. It's not exact, but you can see the property lines, and you can see then if there are, potential encroachments. Now, if something's, looking like it's 10 feet over the property line, even though the lines that the assessor draws on these maps aren't 100% accurate, I would say you have an encroachment. If it's, looks like it's abutting the line or maybe just barely over, you may or may not. I mean, you would have to have a surveyor come out and give you a very, specific and accurate drawing to show whether or not that there's an encroachment there. The other thing is, setback requirements, right? So, just because something might not be encroaching, was that a structure that the city or county allowed within their required setbacks? Or CC&R sometimes have setback requirements. That's something that was allowed by the CC&R. So at the end of the day, there are resources available to figure that out as best that you can. Obviously, the best thing would be to, like a traditional residential sale, to be able to walk the property and inspect and stuff, but that's not available in a trustee sale. So you use the resources available. But you have to watch out for those encroachments, because a lot of times when you buy the property at the trustee sale, unless you're looking for a long-term hold, if you're looking to, maybe do some improvements and then exit out as quickly as possible, well, that may not happen if you have an encroachment. That's something that's probably going to have to be fixed or resolved before you're able to exit out, because a lot of times the title companies will hold up the transaction because they're saying, well, there's a title issue, there's an encroachment. We don't want to be on the hook for an encroachment, so fix it before you sell it or come to us, for title insurance.
What can an investor do about vetting code violations?
Yeah, so code violations are generally going to be recorded, at least here in Maricopa County, either by the county or the city. And so your title search will likely reveal those code violations. You could also go down to the city and see if there's unrecorded code violations and ask them for any information that they have. You can even go to the city for building permits. If you look at the aerial photographs and you say, hey, wait a minute, 4 years ago, this owner added onto the dwelling. Was that permitted? Go to the city and find out, or the county and find out, did they obtain the proper permits to add that structure onto the property? That's the type of research that you can do and should do to determine whether or not this is something you should be jumping into and buying at a trustee sale.
So this is one of my favorites, filled with all types of potential issues. And it really doesn't matter whether it's real estate or some other area of the law, but bankruptcy always throws a wrench into just about everything. So what does an investor do about bankruptcy? And in this context, we're really talking about undisclosed bankruptcies.
Correct. So this is the biggest, well, no, this risk is exclusive to trustee sales. For the reasons we'll talk about, and redemption rights, it's not really a risk on a sheriff's sale because you have 6 months for the bankruptcy to be discovered and for the borrower or the debtor in bankruptcy to come out of the woodwork and say, hey, I filed a bankruptcy that affected this property. But basically, when you file for bankruptcy, when a borrower or individual files for bankruptcy, the second that bankruptcy complaint is filed, an automatic stay by federal law goes into place that says you cannot do anything with respect to that debtor's property.
No matter who you are, you have to freeze.
You have to freeze. It's an automatic stay. You can't file a lawsuit. You can't do a trustee sale. You can't send a demand letter. You can't do anything without going into the bankruptcy court and saying, I'm owed money. Judge, may I do this? And that's called relief from the automatic stay. You ask the court for relief from that to proceed with your rights or remedies that you previously had prior to the bankruptcy filing. But it kicks in. So if you have a trustee sale scheduled for 10 a.m. and the debtor runs down to bankruptcy court and they file that complaint or that bankruptcy petition, it's not really a complaint, it's a petition. They file that petition at 9:59 and 58 seconds or 59 seconds, and they're able to show that via a timestamp on their petition or a timestamp with the bankruptcy court. Even though the trustee has no clue that this has happened, and they go and they sell the property and the purchaser pays for the property and goes through the whole process, receives a trustee's deed, unbeknownst to anybody that a bankruptcy has been filed. And then the borrower or the owner comes out of the woodwork and says, well, wait a minute, I filed for bankruptcy a second before the gavel dropped on that sale, that's not a valid sale. All of a sudden, everything's unwound. Where that becomes complicated and becomes an issue is if the new owner, the person that bought it at the trustee sale, will, they're thinking, okay, I want to do a couple of things with this potentially, right? I want to, make improvements to it so it's in a good rentable condition, and I want to rent it, right? Or I want to improve it so I can sell it. Or I want to make sure that there's going to be no other foreclosure. So I'm going to, make HOA payments. I'm going to pay taxes, real property taxes. I'm going to outlay money for the benefit of this property. And a month later, after the new owner has spent a bunch of money and poured that money into the property, paid taxes, done everything, and they're out, all of a sudden the trustee comes to that new owner and says, hey, guess what? We just found out that this borrower filed for bankruptcy, a second before our sale. I didn't have the authority to sell it because now this property was in the exclusive jurisdiction of the bankruptcy court. Everything's unwound. You no longer own it. And sorry, you're out 20 grand. What's the remedy? I don't know. I mean, could maybe the buyer go in and claim unjust enrichment and try to get some judgment from the bankruptcy court? Maybe. I don't know. I mean, but you're chasing around somebody in bankruptcy. Is that really what you want to do? So that is a big risk, is making sure that there's, not this undisclosed bankruptcy. Now, what you can do to protect yourself from this, and if you're diligent, if you go and you buy the property at the trustee sale and you even get the trustee's deed, what I would do is, before I start outlaying a bunch of capital to improve or pay taxes or pay HOA assessments, I would actually go on and obtain what's called a PACER account. And what a PACER account is, it's an account that you create through a private company that's linked to the federal courts and provides you with access to the federal court docket. That includes the bankruptcy court docket. And then you can take the prior owner's information and name, and you can plug that into PACER and see if they filed for a bankruptcy proceeding anytime within the last couple of months. Once again, it's not foolproof because you have to make sure that you do the right query and, are plugging in the right information. You have the correct and accurate information for the borrower and the prior owner. But nevertheless, it's better than not doing the search. And it's cheap. A PACER account, I think, is free. And then a query is going to cost you like 50 cents, or a search is going to cost you like 50 cents. And then each document's, less than 10 cents. So if it does look like a bankruptcy was filed, then you go and you can print out the information that's been filed with the court, and you can take it. And then I would go to an attorney that knows bankruptcy law or knows real estate, sit down with them and say, okay, this person filed. What does this mean for me? Is this the same person? And I could figure that out for the most part. I could look at the information and take a look at what was filed and say, yeah, that's probably the same person, or no, it isn't. Or if I'm unsure, I could say, well, here's how we find out. And then you go and you figure it out before you start putting a bunch of money into the property.
I want to take this hypothetical in bankruptcy just one step further. So when you buy a property at a trustee sale, you're the winning bidder. It's the trustee who's deeding the property to you by trustee's deed. That process does not happen instantaneously upon the drop of the gavel at the trustee sale. It can take a couple days. Let's say the borrower files bankruptcy, and it's not 1 minute before the trustee sale. It's 1 minute after, or it's a day after, and the trustee finds out, gets notice of the bankruptcy before the trustee's deed has been issued. Does that create a problem?
Yes, it does create a problem. it creates a solvable problem potentially, but a problem nevertheless. So what the trustee is going to do in that case, and like you said before, you and I have served as trustees. I've never come across this problem in my capacity as a trustee, but nevertheless, what, based upon, my knowledge and training and in acting as in that capacity, what I would do is I would say, we're staying everything. We're doing what the bankruptcy court is telling me to do as a trustee. I'm not doing anything until I get further instructions from the bankruptcy court on how I'm going to proceed. And so you basically stop everything. So if the sale takes place, an hour later, the debtor files for bankruptcy or the owner files for bankruptcy, no trustee's deed can be issued at that point because the stay's in place. Nobody can do anything. Instead, what's going to have to happen is the bidder at the sale, and I don't even think the trustee has the ability to unwind the sale, right? Because the sale happened. And so there's a stay, and the trustee, by unwinding the sale, could potentially be violating the stay because you're really not supposed to do anything with respect to the debtor's assets until you receive instructions from the bankruptcy court. And so in that case, what you would do is, as the trustee, you would say, I'm halting until I receive some instructions from the bankruptcy court on how I'm to proceed. So if you're the winning bidder at the sale is probably still valid. But now you have to go into bankruptcy court. You have to hire an attorney, presumably, because bankruptcy is one of those things that, number one, if you're acting on behalf of a entity, you have to hire an attorney because you can't represent an entity in court. An entity has to be represented by counsel. So you have to go in, hire an attorney, go in, file what's called a motion for relief from the automatic stay. And basically what the motion is going to say is, hey, court, at the time that this sale happened, there was no bankruptcy proceeding. So it is a valid sale because it was done before the bankruptcy was filed. However, because the bankruptcy was filed in between the sale and the issuance of the trustee's deed, everything's been put on hold. Court, since we have a valid sale, provide relief from the automatic stay to allow the trustee to convey the property to me as the winning bidder via a trustee's deed and determine or declare that I'm now the owner of this property. So you would do that. And I think you would probably win that. You would probably prevail on that motion. But you're paying an attorney now to do that. So you're out those funds and you're not going to recover those funds. You probably don't even have a right to recover those funds against the borrower because you weren't the original lender, presumably. And so you're out those. You've delayed the process because you're going to have to work your way through the bankruptcy court to finally get a ruling on this motion. So there's an additional cost. And yeah, bankruptcy is going to throw a wrench into that. So it's a problem, but it's a fixable problem if the bankruptcy is filed after the sale.
All right. So bankruptcy, that's a unique pitfall to trustee sales. Let's talk about unique pitfalls to sheriff sales in the foreclosure of mortgages or just sheriff sales generally. Let's talk about, I know you've talked about it throughout the episode here today, but let's talk in more detail about redemption rights.
Yeah. So that's the biggest kind of risk or pitfall with purchasing properties at a sheriff sale. So sheriff sales generally occur in two scenarios. So the first is HOA lien foreclosures. So HOAs have to foreclose judicially. And so if the HOA is owed past due assessments, they have a right to file a lawsuit and file a judicial foreclosure lawsuit and have that lawsuit work its way to judgment and then go and have a sheriff sale of the property. The second is a judgment that's been issued on an unsecured debt and the property's not subject to the homestead exemption, or if it is, the value of the property significantly, or there's equity greater than the homestead. And in that case, then you can go to a sale. And so a judgment creditor can cause and can force a sheriff's sale. So those are the two instances that you're going to see a sheriff's sale. However, the significance is once the sheriff sells the property, they conduct the auction, and you have a winning bidder at the sheriff's sale. Well, all of a sudden, there's redemption rights. It's not a full and complete conveyance of title to the property. Instead, you have to, as the winning bidder, you have to wait 6 months, or it could be reduced as short as 30 days, but only under certain circumstances. And that circumstance is that the judgment giving rise to the sheriff's sale has to specifically state that the property that's going to be sold at the sheriff's sale has been abandoned and has not been used for grazing or agricultural purposes. We were trying to protect farmers, right? It's an old statute. So that's what you have to show. That's your burden. So if you want to be able to reduce the redemption by down to 30 days, you have to show that the property's been abandoned and that it wasn't used for grazing or agricultural purposes. And you have to show that at the time that the original lawsuit was filed and the judgment was entered. Otherwise, it's a 6-month redemption. And during that 6-month redemption, the owner or the successor in interest, which is interesting for our investors listening, is if there's a property that has gone to sheriff's sale and been completed, you still have a right to buy the interest from the owner and redeem that property. So the owner, the owner's successor, or a junior lien holder has the right to come forward within that 6-month period and pay the amounts past due, or the amount, not past due, the amount that the purchase price for the property, plus 8% interest on that amount. So whatever the property was sold for at the sheriff's sale, whatever the winning bid was, plus 8%, plus the amount of assessments paid by the purchaser at the sheriff's sale, and the amount of the taxes paid by the purchaser at the sheriff's sale, plus 8% interest on those amounts. But what the statute does not state in Arizona, and is problematic and can create a major risk, is it does not allow the successful bidder to recover the amounts that that successful bidder may pay to a senior lender to keep that senior lender current and to avoid a foreclosure on the senior loan. So that's where it's very important to understand your lien priority and understand your risk in buying a property at a sheriff's sale. So if I go and let's say the HOA forecloses and I purchase the property at a sheriff's sale as a result of an HOA lien foreclosure, I take the property subject to a first position lien, first position deed of trust, because HOA liens are never ahead of first position deeds of trust by statute. It's very clear. It's black and white. I'm going to be behind a first position deed of trust. And let's say that first position deed of trust is $400,000 and the monthly payments are $2,500 a month. And that HOA, or not HOA, that first position lender is not being paid. Well, I have a right as the purchaser at the sheriff's sale to go in and start writing checks for $2,500 a month to avoid that first position lender from foreclosing. Because if they foreclose at any point in the 6-month redemption period,
you're done, right?
You're done.
Yeah.
I'm out. So you need to write those checks. You need to keep that first position lender current to get to the point of the redemption period expiring so you can actually take title to the property and do something with the property. But the statute doesn't require that the parties entitled to redeem repay those amounts to you. So what could happen is I take the property, I buy it, I'm the successful bidder. I have to wait 6 months before I actually receive title. But in the meantime, I'm gonna avoid a foreclosure on the first. I'm gonna start writing checks to the lender of $2,500 a month. Well, then 5 months later, the owner or the owner's successor comes out of the woodwork and says, "We're gonna redeem. How much are you owed?" Well, the only amount that I'm entitled to collect is that purchase price, the interest, the assessments that I might pay, to the HOA thereafter, taxes plus interest on those amounts. The $2,500 a month, I'm writing checks to that first position lender. That's not covered by the statute. So I'm out that money. I don't get to recover it. I get my money from the owner, their successor, even a junior lien holder, and I'm done. I'm out. And I'm out that money that I've paid to avoid and the first position foreclosure and to avoid losing my money that I paid to purchase the property at the sheriff's sale. So it's a tough position and it's a major risk. So understand your lien priority, understand what it's going to take for you to protect your lien priority and protect your interest in the property, and know that there's going to be a risk there if you buy that property at a sheriff's sale. Risk doesn't exist at a trustee sale because it's a fairly immediate conveyance of title after the sale.
Sure, that's wild. Investors, beware. With that, everybody, that is our episode for today. Thanks so much for being with us. Make sure to be with us next week. We're going to be talking about HOA problems, how to manage an out-of-control homeowners association. You should all be here for that. We've got guest attorney Jonathan DeSalis. He'll be with us to talk more about HOA problems. Thanks so much for being with us. We'll see you next week.
Have a great day, everyone.